You all know that Sahara reporters, they do not lie. They do their investigation. They do their due diligence before putting out any news. You guys would not believe it. It has been established that judges, the Supreme Court judges, agreed to throw away any case that was filed against Tinubu or his inauguration or against Shetima. Just a few days ago, a case that was, submitted to the Supreme Court against Tinubu's swearing in was not only thrown out, but fine, was given to the person, millions of naira. The person was asked to pay millions of naira, you know, after even losing the case. You all will get into that in a bit, but before we do so, if you haven't subscribed to this channel, please do well to subscribe. Turn on the post notification bell so that you can be the first person to get notified whenever we upload a new video. Help us grow this channel by giving this video a massive thumbs up so that it gets recommended to other YouTube viewers all around the world. Lastly, please leave your opinions in the comment section below. Without further ado, let's delve right into the details of today's news. How Chief Judge of a Federal High Court ordered judges not to entertain cases stopping Tinubu's inauguration. The Chief Justice of a Federal High Court, John Tehimba, has reportedly barred judges from entertaining cases bordering on the presidential election or the forthcoming swearing in or inauguration ceremony. This is perhaps to ensure that nothing stops the inauguration of a president-elect, Bola Ahmed Tinubu, as the next president of the Federal Republic of Nigeria. Sarah reporters gather that the chief judge also directed that such cases pending in court should be transferred to Abuja for review. A litigant, Mr. Abdul Yusuf Rufai, who confirmed the development, told Sahara reporters that he was at the Federal High Court Enugu on Wednesday, May 24, 2023, in respect of his lawsuit between Mr. Abdul Yusuf Rufai and the Attorney General of the Federation, which seeks the court's interpretation of Section 134 of the Nigerian Constitution. Rufai said a senior court official told him that there was an order from the Chief Judge of the Federal High Court of Nigeria that no judge in Nigeria should hear any suit on presidential election or swearing in. This is a travesty of justice from the judiciary and an abuse of constitutional powers calculated to kill the substance of my case and dodge May 29. My lawsuit was immediately transferred to Abuja, he said, in a text message sent to Sarah reporters titled UB Just, UB Remedium, where there is a right or law, there is the remedy, Rufai said. Fellow citizens, owing to my complaint of a breach of my fundamental rights and freedoms and in furtherance of or enhancement of my inalienable rights, ditto for millions of Nigerians, I have approached the Federal High Court for its intervention, and amongst the reliefs I sought, I asked the Honorable Court to interpret and give a simple understanding and intendment of Section 134 of the Nigerian Constitution, which is our grundnorm and supreme document in the land. I have also asked the Honorable Court to use its inherent power to stop the swearing in or inauguration of any purported president on May 29th, 2023, not duly elected because of not meeting constitutional requirements or because of violating constitutional provisions and its violability in the last presidential election. I have also asked the Honorable Court not to allow unconstitutionality or illegality of any sort to stand, but to defend the rule of law, uphold our Constitution, promote stability, protect our democracy, and render justice to the satisfaction of man and our Creator. Meanwhile, a covering letter of transfer of his case to Abuja dated May 24, 2023, and obtained by Sarah reporters was addressed to Deputy Chief Registrar, Litigation, Federal High Court, Abuja. It was signed by Deputy Chief Registrar Femi, titled Transfer of Case File between Mr. Audu Yusuf Rufai and Attorney General of the Federation and the Attorney General of the Federation. The letter reads: pursuant to the circular by His Lordship, the Chief Judge of the Federal High Court on case bordering on presidential election and the forthcoming swearing-in ceremony, I have been directed by His Lordship Honorable Justice M.J. Omar to forward the above referred case file to your office for the attention of the Chief Judge of the Federal High Court for further necessary action. And the suit, which commenced by way of originating summons brought pursuant to Order 3, Rules 6, 7, and 9 of the Federal High Court, Rules 2019, and under the inherent jurisdiction of the Honorable Court, the applicant, Mr. Abdul Yusuf Rufai, formulated one question for the determination of the court. A declaration that Section 134 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, provides for a mandatory win of at least 25% of the FCT Abuja votes before a candidate of any political party in Nigeria must be declared the winner, duly elected, of a presidential election in Nigeria. A declaration that the purported president-elect, Mr. Ahmed Bola Tinubu of the All Progressive Congress (APC), from the result as announced by the Independent National Electoral Commission (INEC), did not meet the compulsory provision of Section 134 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to be declared duly elected and cannot be sworn in as the President of the Federal Republic of Nigeria. You all, let me have your thoughts in the comment section. What do you think about this? Subscribe if you haven't. Thank you very much for always watching and listening. I will see you in my next video. Bye for now.